Hello everyone, I'm Aratrika Bhaumik and I welcome you all to another episode of Courts This Week on Live Law, where we update you about all the important legal developments that took place across the country last week. We will begin with developments from the Supreme Court of India and then move on to High Courts and other subordinate courts. If you like our content, it would mean a lot to us if you could like and subscribe to our YouTube channel. Let's begin. The Supreme Court of India has observed that the Bar Council of India, being a major body, has to come up with propositions to handle situations regarding advocates agitating and going on strikes. A bench comprising Justices Dinesh Maheshwari and Sudhanshu Dhulia remarked, and I quote here, "This is a matter which should concern all of us, not only on the point of law, but otherwise as well, and all of us have to apply ourselves in this matter." The bench also expressed that the Bar Council of India has to play a major role to come up with some effective solution. The Supreme Court of India has reserved judgment on a batch of petitions challenging the decision taken by the Union government 6 years ago to demonetize the currency notes of Rs 500 and Rs 1000 denominations. A constitution bench comprising Justices Abdul Nazir, B.R. Gavai, A.S. Bopanna, V. Ramasubramaniam and B.V. Nagaratna heard arguments in a batch of 58 petitions. The bench allowed the parties to give written submissions by December 10th. Pertinently, the court also asked the Union government and the Reserve Bank of India to produce the relevant records in a sealed cover. The Supreme Court of India has converted a writ petition filed under Article 32 of the Constitution into a special leave petition filed under Article 136 to consider the legality of a High Court order which had quashed a case against a school teacher for allegedly molesting his student based on a compromise with the family members. A bench comprising Justices Ajay Rastogi and Bela M. Trivedi was considering a writ petition filed by a third party, highlighting that the High Court has allowed the quashing of a criminal case against the government school teacher based on a compromise. Providing its current stand on the issue of extending the benefit of reservations available to the scheduled caste community to Dalits who have converted to other faiths, the Solicitor General of India has informed the Supreme Court that the Union government has decided to not go by the report of the Raghanath Mishra Commission report and has instead appointed a new commission headed by former CJI Justice K.G. Balakrishnan to examine this issue. A 3-member commission has been appointed in October this year to examine the issue as to whether the scheduled caste status can be granted to Dalits who have converted to religions other than Sikhism and Buddhism. A review petition against the order acquitting the 3 men accused in the 2012 Chawla gang rape case was mentioned in the Supreme Court before a bench comprising CJI D.Y. Chandrachud, Justices J.B. Pardiwala and P.S. Narasimha. The council has highlighted that the public's confidence has been shaken due to the conversion of the capital punishment to acquittal in this particular case and has accordingly sought an urgent listing of the matter. CJI D.Y. Chandrachud stated that he will take a call on this after going through the files. The Supreme Court of India has dismissed a curative petition filed by an organization, Roots in Kashmir, seeking probe into the killings of Kashmiri Pandits during the heights of militancy in the valley during the 1990s. The bench of Chief Justice of India, D.Y. Chandrachud, Justices Sanjay Kishan Kaul and S. Abdul Nazir observed that no case for interference has been made out within the parameters indicated in the Supreme Court's decision in the case of Rupa Ashok Hurra vs. Ashok Hurra. The Supreme Court has dismissed a petition which sought for details of the Supreme Court Collegium's meeting of December 12, 2018 under the Right to Information Act, observing that the discussion cannot be disclosed to the public and that only the final decision of the Collegium needs to be uploaded on the website. The Supreme Court observed that only the final resolution can be considered as a decision and that whatever is discussed is not required to be in the public domain, that too under the Right to Information Act. The Calcutta High Court has held that writ jurisdiction of High Courts under Article 226 of the Constitution is invocable even for cases involving ordinary commercial transactions between private persons and public bodies as long as some element of public law is involved in the concerned commercial transaction. A division bench of Justices I.P. Mukherjee and Biswarup Chaudhary has, however, clarified that such invocation of writ jurisdiction is constrained only to cases involving disputed questions of fact which are not very intricate or complicated and are capable of being established through evidence affidavits. The Delhi High Court has directed the Bar Council of India to inform it about the next scheduled date of the All India Bar examination, which was last conducted on October 30th, 2021. Justice Pratibha M. Singh also asked the BCI to consider having a preset schedule for the conduct of the examination so that the uncertainty regarding the dates of the biannual examination can be resolved and that provisionally enrolled advocates can prepare accordingly. Keeping in view that the AIB examination was not conducted after October last year, the court clarified that Rule 9 of the All India Bar Examination rules would not be operational with respect to the advocates who are unable to clear the examination within the period of 2 years of their provisional enrollment. The Delhi High Court has allowed a 33 weeks pregnant woman to undergo medical termination of pregnancy. The court has underscored that the ultimate choice in the pregnancy cases involving fetal abnormalities is of the mother and that the medical boards in such cases must give qualitative reports. Allowing a 26-year-old married woman's plea seeking medical termination of her fetus of over 33 weeks who is suffering from cerebral abnormalities, Justice Pratibha M. Singh ruled, and I quote here, "In conclusion, the court holds that the ultimate decision in such cases are to recognize the choice of the mother as also the possibility of a dignified life for the unborn child." Filmmaker Vivek Agnihotri has tendered an unconditional apology before the Delhi High Court for his remarks against Justice S. Muralidhar with respect to the judge's order quashing the order of house arrest and the transit remand of activist Gautam Navlakha in the Bhima Koregaon case. The court had initiated suo motu criminal contempt proceedings in the matter back in 2018. A division bench of Justice Siddharth Mridul and Justice Talwant Singh has allowed an application moved by Agnihotri seeking permission to appear and participate in the suo motu proceedings. Days after the messaging app disclosed their identity details, the Delhi High Court has issued summons to the Telegram users accused by India Today Group of infringing its trademarks as well as copyrights. On November 29, Telegram had placed on record the identity and the basic subscribers' information of the defendants in a sealed cover before the court. The parties were directed by the court to keep the information confidential. However, the court has clarified that disclosure to any government authority or the police authorities is permissible. Thank you. Keep watching Courts This Week on Live Law for more such updates. See you next week.